SJC-12973, Commonwealth of Massachusetts, from the relator, Johan Rosenberg, v. JPMorgan Chase and Company, and others.
Okay. Attorney Singh.
Thank you, and may it please the court. This case calls on the court to interpret as a matter of first impression the language of the public disclosure bar provision of the Massachusetts False Claims Act. This provision is modeled after a provision of federal law that's designed to deter and prevent parasitic or opportunistic False Claims Act actions, which means cases where the qui tam relator, the plaintiff, is trying to take a piece of the government's recovery for a fraud without adding anything meaningful to the fraud recovery effort. In this case, my client, the relator, became independently suspicious that the defendants were defrauding the government in connection with the remarketing of certain bonds. And he performed an independent forensic investigation based on data he purchased. This investigation involved over 1,000 hours of labor, reviewing around 5 million data points relating to over 20,000 bonds. And based on that, concluded that there was a high likelihood that fraud was occurring and brought this action. He also had consultation.
I don't mean to interrupt you, but I'd like to get right to that point. You mentioned in the verb you used was that your client purchased it. And the factual basis of your client's complaint is 4.5 years of data that was publicly available on industry websites and on the Emma website. And so to get squarely to the point, even though you might have paid an access fee, doesn't it rest on substantially similar transactions that are expressly contemplated by the public disclosure bar?
No, Your Honor, and that's for two reasons. The first one is the Emma website, and I think this is probably the easiest basis on which the court could reverse, is the public disclosure bar only applies to disclosures that occur in the enumerated channels in the statute. And the question here is whether the Emma website, which is a government website run by the MSRB, the Municipal Securities Rulemaking Board, is the news media. And I think no one would say it is under the way we ordinarily use that language. That is what a court in California.
But counsel, don't you run into problems in saying that nobody would weigh it this way or read it this way when, as you started your argument, our statute is modeled under the federal statute, and the federal courts have all interpreted it, or at least the ones that have been cited and certainly relied on by Judge Kaplan below, all interpret it as including publicly available websites. So the notion that nobody would interpret it that way when the federal courts have interpreted that way doesn't seem to be persuasive.
Your Honor, that's not a correct characterization of the federal cases. So let me just say there's only one case about, well, there's two cases now that have talked about whether Emma is the news media. The California case that we included in our addendum to the brief.
But can I stop you there? Because I don't want to focus on Emma per Emma. I want to focus on publicly available websites. So is it your contention that there are federal courts interpreting the federal statute that have found that publicly available websites are not included in the news media?
Yes, Your Honor. We've cited two of them to you. The first one is the Integra meta-analysis case. That's a case from the Central District of California, which is the decision that we rely on most heavily in our opening brief. And that case said, not everything on the internet will qualify. You should ask whether it's news media as the term is ordinarily used, and provided several indicia, including, does the site resemble traditional news media? Does it gather information, exercise editorial judgment about what to publish, and then publish it, which Emma doesn't? And similar guideposts that we don't think Emma falls under. The second decision that I'd recommend to you is one that we cited in our Rule 16L letter, and that's our, I believe, December 22nd letter. And that one is the Silbersher versus Allergan decision. So that the website in that case was PAIR. It was the Patent Application Information Retrieval System, a government website like Emma, where regulatory filings or patent filings are basically regurgitated by the government on a publicly available website. And the court said, no, this does not look like news media. This is not news media. Again, adopting the rule that when you have a statute that doesn't define a term, you're going to use the ordinary meaning of the term. And the ordinary meaning of news media generally does not include websites like Emma that are run by the government, that just put out tables and tables of data with no news or editorial content whatsoever. I mean, one way you could even think about it, and I don't want you to adopt this rule because this is broader than it needs to be, but the fact that Emma falls outside this rule is pretty good for us. If the First Amendment would not protect a website, there's a pretty good argument that it's not the news media. And in this case, Emma is really a creature of the regulatory apparatus of the federal government. If Congress passed a law tomorrow saying no more Emma, I don't think there would be any problem with that. Contrast that with the Boston Globe, the New York Times, which obviously you can have. Now, news media is narrower than just what the First Amendment reaches, to be sure. That's our argument too. There are other things that we would use in ordinary speech to decide if something is news media. But at the absolute minimum, I think it's pretty clear. And I would say also, just hearkening back to this California decision, it was based on a published appellate case in California called Bartlett versus Miller. And in that case, the court decided that EDGAR, which is the Securities and Exchange Commission's website that, like Emma, regurgitates the securities filings of publicly traded companies, was not news media either. The court actually said, wherever the fuzzy line is between websites that are the news media and websites that aren't the news media, we're quite confident that EDGAR is not there. Now, the defendants in this case have really no good answer.
Can you finish that thought? Because why?
Oh, because
EDGAR is not there because why?
Oh, sure. Because again, news media has a pretty settled ordinary meaning. It's the professionals who report on current events to the public. And EDGAR, all EDGAR does is kind of exactly what Emma does. It takes the filings that are required by regulation to be submitted by issuers, and then it reproduces them for people to see. But there's no editorial judgment. There's no news reporting of any kind. You know,
I'm asking, this is specifically with regard to that case, that was the analysis, that was the rationale. It was because there was no editorial aspect of the posting.
I think that's right, Your Honor. So it's not entirely clear what all of the factors the court was relying on are, but the court very clearly stated, I'm paraphrasing it very closely when I say, it said, wherever the line is, this is not close to it. And that's because if you use these websites, you know that they don't really resemble the news at all. They're not what you would think of as a place where you would go. And what's I think very helpful for us is that Emma
not a place you would go for what? Can you finish that thought? Not a place that you would go
for your news. You know, you don't wake up in the morning and say, I'm reading the news, I'm getting on Emma to look at tables of data about interest rate resets.
But if you wanted to know about what company X is doing, you would look at their SEC filings. So that can't be the test. So what is your test for what is a news?
No, you might well do, Your Honor, but at the same time, here's another thing. Let's take a company, let's take, McDonald's, the fast food chain. You might look at their SEC filings. You might also go to the McDonald's website. But I don't think people would say that the McDonald's website is the news media. Just to be clear, the statute does not say if it is news.
I'm trying to figure out what test you would apply for the news media. What is it?
Oh, sure.
Now, I know what you think it's not. What is it?
Sure. So if I had to just phrase the rule, I would say the court should hold that the phrase the news media takes its ordinary meaning, which is professionals who report on the news to the public. Right? That is the news media. When people talk about the news media, they mean these folks who do this for a living, who gather the news and report the news. And that there may be, I will acknowledge, there may be hard cases at the boundaries where you're trying to decide, is this particular website, Joe's blog or something, is this the news media or is this not the news media, right? And you would have to decide those hard cases. But I don't think Emma falls anywhere near the hard cases. And that's because it really is not designed to report the news to the public. It's designed to gather and reproduce the regulatory filings of issuers.
But counsel, don't we at this point, considering where we are with the internet and websites, need a new definition of what news media is?
Your Honor, I think if that were true, the definition really needs to come from the legislature and not from the courts. I think what's happened in some of these cases is that the courts have said, look, we think we're going to construe news media broadly to include every readily accessible website because they're designed to disseminate information to the public. That is not really what Congress intended when it passed the federal statute, nor the general court when it enacted this statute. And the statute was updated as recently as 2012. So it's not as if the internet was a new phenomenon. If the legislature wanted to say internet, it would have been very easy to say internet, either in 2012 or when Congress updated the federal statute in 2010. The internet was in widespread use at the time. And so I don't think it can be right that every readily accessible website trying to provide information to the public counts. Again, the McDonald's company website, you just wouldn't call it news media. And by the way, this is also just supported by the basic canon of statutory construction, that when we have a term that's not defined, we use the ordinary meaning. And if the legislature wants to give it, yes, sir.
I apologize. Please finish your answer. I thought you were done.
Oh, I would just say if the legislature wants to give it a special meaning, it certainly can do so. Right? There is no reason the legislature could not make this pellucid. And I think if there's ambiguity here, then the other rules of statutory construction that matter are the ones that say, let's construe remedial statutes in favor of recoveries, and let's construe the exceptions to those statutes relatively narrowly. Reading news media as broadly as possible runs contrary to those settled principles as well.
So, Mr. Singh, let's just assume, because you've only got a little time left, let's just assume, for the sake of my question, that Emma falls within the definition of news media. I want to get to original source, and I'll sort of tell you why I'm asking before I ask you. I'm having a hard time figuring out the answer to that based on this record and a motion to dismiss and my limited knowledge of municipal bonds, I have to say, and even getting my arms wrapped around exactly what you call robo resetting is as it relates to remarketing. But if we are dealing with the news media and the situation is that this raw data was actually publicly disclosed, and you want to say, well, look at this value added that my client gave. This raw data just isn't useful without this forensic analysis that my client did. And so he's an original source. How do I know that? How do I possibly understand that from the papers? Assume I have an aptitude for it, which I don't. How do I figure out the answer to that, whether he's an original source?
Sure thing, Your Honor. So I'll point out I want to speak to your question directly. There are two arguments we make based on the sort of what's out there in the public domain. The first is that it doesn't actually disclose the relevant fraud, but I'm assuming for purposes of your question that you've gone past that step. And now we're at just whether there's an original source. To argue that we're an original source, there are two requirements. We have to have knowledge that is independent of and materially adds to the publicly disclosed allegations or transactions. And we have to disclose that information to the government before filing the case. I think the first requirement is really what we're talking about. Is the knowledge independent? So we know that the data was acquired independently of the public source. We know that all of the analysis done on the data.
Counsel, can I interrupt you with that answer? But you say that, but in your complaint, although you allege that there were multiple kind of insiders that your client spoke to, the complaint only alleges that he spoke to one Bank of America employee. So how do you say that? So wouldn't it suggest that it's really all publicly available information that your client relied on?
So, Your Honor, I just want to be very clear about what I'm talking about here, which is not the conversations with the insiders, but the data itself. So as you noted in your first question, Justice George, is the data, even if we purchased it, isn't it the same as what's in the public domain? And to some extent, it's similar to part of what's in the public domain. But the point that we got it independently actually matters here. And so for purposes of whether the knowledge is independent, that's part of it. The other part of our independent knowledge, there are two other parts, is what I would describe broadly as the expertise and labor and analysis And then the third part is the conversations with the industry insiders. And I'll speak to that as well if I can. But on the second part, which is what I think is a critical piece of this, is to determine whether knowledge materially adds. I mean, this is a sort of fuzzy statutory term, but it's designed, I think, to be flexible. I think you would look at this in context and you would say, okay, you have this data on Emma, these tables of information. And could you, looking at that, infer fraud without doing a ton of labor? The answer is, and having a ton of knowledge. And the answer is no, you can't. Now, there's a couple of reasons why. First, the data on Emma is actually, in the form you get it on Emma, not terribly usable at all. Emma, for example, does not allow you to scrape the data wholesale using AI or bots or anything like that to get it. If you want to get a data set that you can actually run models on, that you can actually analyze in meaningful detail to do the type of analysis we did in this case, you actually have to get it from the MSRB through another channel. You have to buy it the way we did. You can't just copy and paste it. It doesn't work that way, especially not for the quantities of data that we're talking about here. And it would violate Emma's terms of use to do so. So that's one.
How do we, I know that. How do I figure that out from this record? Because there's all sorts of cases saying that, you know, because you've got value added to the VRDO's data on the website. No doubt, you've added some value here with all of your experience and proprietary methods. But what you just said, how do I know that from the record?
Sure. So I guess my answer would be, if you don't know that from the record, you should rule in our favor, because this is a motion to dismiss on the pleadings, and this is an affirmative defense. And so if they want to make it out
should
at
it
this
be
point,
a summary judgment with depositions and affidavits, and some poor Superior Court judge is going to then write an opinion about whether this is value added or not?
Your Honor, the need to write that opinion would arise whether it's at the pleading or the summary judgment stage. I think it's going to be decided. But I think, yes, I think if this is a question on which you think the record is underdeveloped, then the straightforward answer is that for purposes of pleading an affirmative defense, you know, the defendants haven't done it. And so the case would go on, and they would try and present the case that we have not added value, and we would try to argue that we have. Now, as to whether as a matter of law something materially adds, I think that's, you know, the word material is a pretty ubiquitous term in the law. And I think it refers to just whether you've done something, you know, not immaterial, that is something that moves the needle a bit. And I think it's very hard to say that we haven't in this case. The analysis that we did was, as I said, it's not just collating the data in a way that's important. It's then doing the forensic analysis, and the analysis is complex. The analysis involves considering, as I said, over 20,000 bonds, almost 5 million data points. And there was a court in Illinois which considered a parallel action to this one that concluded that my client is an original source for precisely this reason. I'll put it this way. One of the arguments the defendants are sure to make when they get up for you in just a moment is that the application of expertise to publicly available information alone just doesn't get you there. And I think that's wrong, but even if it's right, nobody, no matter how expert, could look at the data on Emma and come up with the conclusions that my client did. You needed the labor as well, the substantial amounts of additional analysis. And, you know, that extra work is valuable. And just as we talk about what the False Claims Act is designed to do, what the Public Disclosure Bar is designed to do, it's not designed to discourage people from spending thousands of hours helping the government redress frauds on the government. It's designed to encourage that behavior, to enlist the citizenry to get us out of this hole of fraud that the government finds itself in. And the idea that the only people who should be rewarded are people, and here's a problem that I think comes up. If you want me to just identify, and I know I'm over time, so I'll end with this unless there are other questions. If I had to identify the taproot of the mistakes that happen in interpreting the False Claims Act, it's that people make an unwarranted negative inference. They say, oh, this statute is designed to reward insiders who come forward with insider information. And from that, they draw the negative inference that actions by outsiders based on expertise hard work and honest inquiry into what's going on are disfavored. And that's just not right. What Congress wanted and what the Massachusetts legislature wanted was a robust anti-fraud enforcement effort, which enlists the entire citizenry to help. And so when you're construing terms like, does this materially add, is this independent, were these allegations disclosed? You'll want to pay, I think, very close attention to the idea that this isn't really about knocking all the outsiders out. It's about knocking out the parasitic and opportunistic cases where all the information is really right there, and all somebody has done is repackage it into a False Claims Act complaint. That is not this case. In this case, you couldn't have gotten here without tons of extra labor and knowledge and expertise.
Does anybody have any other questions? Great,
No, thank you.
thank you. Let's move on to Attorney Hockman. Morning.
Thank you. Good morning, Your Honors, and may it please the court, Rob Hockman on behalf of Morgan Stanley and presenting argument on behalf of all the defendants. I'll just start with the general observation that Justice Wendland made at the outset, which is the case law lines up entirely in our favor in this case on three really settled principles of law, and they've been settled with respect to news media for as long as the internet has been in existence, and with respect to the argument that adding analysis to publicly disclosed historical facts since at least the 1986 amendments. First, when all the historical facts on which relators' claims are based have been publicly disclosed, and that is this case, the relator merely analyzes those facts in some way he considers unique, the public disclosure bar applies. And relator here added no facts to the public, none. He offers only his assertions after he analyzed publicly available facts. And Mr. Singh tried to make it sound like his analysis added something. It may have added his spin, but he added his spin the relator added his spin only to publicly available facts. And I want to set one thing absolutely clearly aside on this. If you go to the second volume of the appendix, pages 195 to 196 of the transcript, this was after a dogged effort by Judge Kaplan to get the relator to pin down the relator. What did you rely on? He said he relied on the information from Emma. That is true as a matter of fact. We heard today about other data that he had to pay for. It's the same data. It's just a different form.
But counsel,
Yeah.
thank you, Justice Wendland. Doesn't he spend 1,000 hours analyzing 20,000 individual bonds? I mean, how does that not materially add to the raw interest rate information that was publicly available on Emma?
Well, there's two things to say about that. First of all, the case law lines up 100% for a hard and fast line, distinguishing between analysis on the one hand and historical facts on the other. What you have to materially add are historical facts. That's the rule. And that has been the rule. That's the rule. It doesn't matter whether you're talking about substantially the same transactions or whether you're talking about original source. Ondas from the First Circuit, Stinson from the Third Circuit, the JDJ case from the Southern District of New York, I specifically commend to you because more or less every argument you heard today and every argument you've heard in the brief has been specifically addressed by that JDJ case in the Southern District of New York. And that rule is hard and fast for a good reason, because you can allege complicated analysis, but everybody agrees that facts in the public domain are never going to say something like, I've committed fraud. There's always an element of inference involved. And how is a court, as Justice Lowy was getting at, how is a court supposed to understand when you've crossed the line from sufficiently sophisticated to insufficiently sophisticated or too simplistic? There's nothing in the statute to guide you on that. The phrase materially add, by the way, Justice Georges, occurs only is with respect to the original source. And the phrase is actually materially adds and is independent and materially adds, both. And the one thing we know here, you don't have to talk about materially adds. because the one thing we know with 100% certainty is it's not independent. It is an analysis of the very data that has been publicly disclosed.
Mr. Horstman, what do you say about the plaintiff's view that the 2010 amendment changes the nature of the public disclosure analysis, and that now it's an affirmative defense? Does that throw out some of the precedent that you just went through?
Those amendments throw out none of the precedent I went through, Your Honor, for two reasons. First of all, the statutory language upon which that precedent is based was unchanged by the 2000 amendments. The 2000 amendments removed the phrase "based on" from the basic statute. But what the reason it did that was to resolve a conflict in federal courts of appeals, and the Fourth Circuit had taken a somewhat unique view. And what they put in its place is substantially the same transactions, which is the very standard upon which we're relying. And that, by the way, contrary to Relator's suggestion, that was the broader, that actually was the broader view of the public disclosure bar. So it's not as if Congress and the Massachusetts legislature following Congress has been taking a uniform step to narrow the public disclosure bar in the way Mr. Singh suggested. Sometimes they broaden it, sometimes they narrow it. They're constantly trying to find the proper balance between, on the one hand, permitting private entities to ferret out fraud, and on the other hand, not just, by the way, parasitic lawsuits, but lawsuits where others come in and attach themselves, force the government to engage in investigations that are premature, might even, I hasten to add, and that, by the way, the Findley case from the DC Circuit talks about this, and I would hasten to add, also, you have to find the right balance to ensure that there aren't harassing lawsuits, because what we're talking about here are parties that are engaged in contractual relationships with the government. And if there's a kind of litigation tax, because it's so easy by virtue of clever pleading to take publicly disclosed information that could be presented to the government, they can make their own decision, but you wave your hands and claim that you've done some kind of magic analysis. And by the way, statistical analysis is not, I don't doubt the relator's expertise here. As I've said, expertise in the case law is 100% insufficient to get out of the
Counsel, can I interrupt you for a second? Because I think
Sure.
we're getting into policy issues, and I really want to stick with the statutory language. Why is it that news media, I get the federal courts have, except for these two that the relator has brought up, interpreted news media to include publicly available websites, but it seems to me persuasive that that news media is narrower than publicly available websites. That if somebody wanted to include those websites, they could have expressly said so and not said news media.
Well, two things to say about that. And when the amendments were adopted in 2010 and the federal in 2012, it's not like the internet didn't exist. They didn't change.
But I don't see how that helps you.
Well, but the cases had already started to recognize uniformly, without exception, that publicly available websites, that is the phrase that's used. Publicly available websites designed to provide information to the public. I think that's an important qualification. It's the purpose. We are not here, and I think the relator spends a lot of effort to characterize our position as everything on the internet is news media. That is not our position. You do not have to rule that way, and we don't think that would be a correct ruling. And in fact, we've cited cases, Simpson from the District of New Jersey, which talks about informal message boards and community forums. That's not news media. Leotine from the Southern District of Illinois, which talks about an internally directed newsletter of a university website. That's not news media either. But what makes this case, and I agree, by the way, with Mr. Singh, that there might be hard cases. He talked about private company websites like McDonald's. The fact is, the case law has often said that private company websites are news media. But this case is easy, I think. And here's why. Nobody doubts that trade publications are and should be considered within news media. The Radcliffe case from the Western District of Virginia, which says published scientific articles and trade journals are news media. Doe v. Staples, which is a private company data collection of shipping manifests, news media. And the reason why that's so is quite obvious. It's not that news is always generally, everybody is interested in it, like election news or some national election news. There's a lot of news that is niche, that is specific to a specific industry, and news and trade publications serve that function. And if you look at pages 37 and 38 of our brief, you'll see exactly why the MSRB created Emma. And the fact is, what the MSRB is doing is indistinguishable from trade publication information. Sometimes what you want from a trade publication is not somebody's spin. That's not the only kind of news. A lot of times, and especially in the decentralized news media world we live in today, what you really want from the news is, as they say, just the facts. Just the facts. You can make up your own mind. And sometimes news media is putting out just the facts. And that's exactly what's going on here and what you'd expect from something that's akin to a trade publication. And so for that reason, Your Honor, we think this is actually an easy case. And we think, for what it's worth, and we've gone through this in our brief, that even the relator's favorite case, IntegraMed, which, by the way, I don't actually think really changes the territory all that much, because it doesn't actually apply its own analysis in that case if you read all the way to the end. But even if you did, and you applied it to what the MSRB's decision to collect and publish this information on Emma, what you'd find is that there's nothing about working through those factors that leads to the conclusion that Emma is not news media. Quite the contrary. Trade publications are traditional news media, and Emma is like a trade publication. It's a traditional source of information for interested parties in the municipal securities market. The information is made widely available, as everybody agrees. The specific trading information issue, it's just like stock quotes in a newspaper, as we've argued, and stock quotes are just facts. But of course, when newspapers publish stock quotes, nobody would doubt that those specific pages of the newspaper don't count as news media. Of course it does. And so it wouldn't be a stretch at all, even in common parlance, as Mr. Singh suggests, to refer to the MSRB's decision to publish the information on Emma as news media. And even if you go through—
Can I ask you a question? Because this isn't entirely policy, it's also the interpretation of the statute. So if we follow your logic that it reports just the facts, and all of these facts in aggregate form mean a whole lot of nothing to people that don't have any inside baseball. And to the point of Attorney Singh's brief, the governments can't be at all places at all times. So if you don't have interested members of the citizenry saying, I'm going to take all of these facts, these thousands and thousands of pages and line items of facts, and distill them and analyze them and see if I can do what I know the government just practically can't. Doesn't it frustrate the whole purpose of the statute if we construe it the way that you're asking us to?
I don't think so, Your Honor, and that's for two reasons. Again, first, because the notion that specialized knowledge, and now I'm just going to read from Finley, a quote from Finley, the DC Circuit case from 1997. If a relator merely uses his or her unique expertise or training to conclude that the material elements already in the public domain constitute a false claim, then a qui tam action cannot proceed. This has been the rule from the start. And it's because this is the only way to prevent the balance from tilting too far in the other direction. Justice Lowy asked specifically about how courts are supposed to figure out what is, enough magic, enough expertise. And the courts have already sided on that. They said this is not a question for the courts. And when Congress and the Massachusetts legislature addressed the statute, they didn't try to introduce this morass of trying to figure out how much expertise should count. Instead, what they did is they left it where it belongs. And this is, I think, an important answer to your question, Justice George. It belongs with the Attorney General. The Attorney General has the right to intervene. They get shown this case. They can sit down with the relator and try to understand. The Attorney General has access, has access to much better resources to evaluate the information, Justice Lowy. And as a result, the Attorney General can not only make the decision about whether to intervene, but But even if the Attorney General doesn't want to intervene, the Attorney General can also just basically say if it wants, as it did in Illinois, the Illinois case that Mr. Singh referred to was up on review at the order of the Illinois Supreme Court. That original source ruling was going to be reviewed. And the Illinois Attorney General said, you know what? I've made the decision properly given to me in the statute that the original source exception shouldn't apply here. That's in the Massachusetts statute also. So my suggestion is leave this judgment where it belongs. It's up to the Attorney General. The Attorney General here has chosen not to intervene. They're better equipped to handle it. And the courts ultimately just can't do the job. It's just going to be, at least can't do the job on the basis of the statutory language that we have now. If the Massachusetts legislature can sit down and figure out a form of words that's going to enable them to figure out how much expertise does it. And anyone, Justice Georges, can say, oh, I worked thousands of hours, 20,000 data points, blah, blah, blah. Computers can do a lot of data points and a lot of data analysis on the basis of an algorithm awfully fast. We know that now. And Justice, when I get the sense you're going to ask a question. So
I was actually going to ask permission from the chief. Can I ask one more question there?
Yeah, of course.
So one of the things that your brother pointed out was that the interpretation of the judge below really leaves outsiders. It limits these key tam actions to insiders and leaving outsiders out. What is your response to that?
I don't think that's true. Outsiders can add facts. Look at the Kennard case from the 10th Circuit. The Kennard case dealt with the mining royalty rates. And what the Kennard case involved was not an insider. It was just somebody who actually was familiar with neighboring land mining royalties and how they've been paid, and had a chance to look at the publicly disclosed information. From the publicly disclosed information about the mining royalties paid to the government, in that case a Native American tribe, you wouldn't know. It's only by the comparison of the other information that he had. And sometimes, look, I don't deny that an investigation from outside might reveal non-public historical facts, but the line is historical facts, not my sophisticated analysis. That line is settled in the cases. It's the legislature has chosen not to cross that line. And if that line needs to be crossed because big data and the world has changed and so on and so forth, then the legislature should amend the statute and provide a workable judicial standard for drawing that distinction. Until then, leave it with the Attorney General.
Let me ask. I actually have a question for you.
Sure.
Given the fact that we're interpreting our statute that was passed by our legislature, and I understand you've got a lot of cases from interpreting the federal statute. Why shouldn't we just look at the plain meaning of what news media means, because that's what's in our statute, and as a court, as we're supposed to do, interpret that and decide what it means?
Well, as an initial matter, I don't actually think that if you interpret the plain meaning of news media, you'd get a different outcome. You're certainly free to do so. But our view is that under the plain meaning of news media, as I said, trade publications are news media, and AMA functions as a trade publication. And ultimately, what you'd find is that the plain language of news media is fairly broad. It just means information of interest to the public disseminated through any particular channel. And that comfortably covers publicly available websites designed to provide information. And I hasten to add also, I want to be clear about this because a lot of this is made in the reply brief. You do not have to say, and we do not believe that PACER it has to be news media. That doesn't have to follow. What PACER is doing is different than collecting information from others and making public what wasn't previously public. Court dockets have been public forever. And all PACER does is save me the trouble of having to wander down to the federal courthouse to get that court docket. It's like a bridge from my house, from my computer, to the court clerk's office. And that's all. That's different. That's a little bit more like a forum as I said earlier. This is altogether something about the decision that was made by the MSRB to collect this information for the specific purpose of enabling the public to look at it and make judgments and make decisions about how to interact with this market.
And anybody can do that.
And anybody can do that.
And just again, why is this something that should be decided on a motion to dismiss as opposed to letting it go further to say whether or not that,
Well, because the only reason that's been given for going further would be to inquire into the sophistication of the analysis. And as I've said from the start, the sophistication of the analysis is just not a question that the statute asks courts to answer. And that's the hard line. And Chief Justice Budd, let me just also add that, with respect to whether the Massachusetts courts should interpret its own statute, of course it should. But I think it's actually fairly important, and I think one of the amici for the relator emphasized this point to keep the state statutes aligned with the federal statute, both in terms of their language and their interpretation, not only for consistency in the law, which is generally desirable, but also because of the relationship between the federal and state government in a variety of different programs.
all right. Thank you, gentlemen. That'll conclude our oral argument for today. Thank you so much.
Thank you, Your Honors.